So my name is Yancey Burnett. I'm glad that I've already met some of you. I'm glad to be able to meet the remainder of you, hopefully today. And so I hope you'll forgive me. I struggle with the stage. I'd rather be down here with you guys. So I'm going to talk a little bit, and then after I finish talking a little bit, then we're going to have a Q&A where you can ask me questions and so forth and the packets that you've received when you first walked in the door give you some guidance about how to ask those questions. And so please address those questions in that way, and that's the easiest way and the most efficient way for us to handle those questions. So we start out with a prayer for a reason, because there is a purpose to this. And so the purpose starts in Christ. You should know that there's a godly purpose to helping children, to saving children, to helping families. God made it a purposeful choice to put families, moms, dads, kids at the heart of families, family units, and for that matter, civilization as we know it. Families are at the heart of that. That means moms and dads. That means moms and dads raising kids. That is not an accident. That is purposeful. It is intentional, and it is God's purpose and God's intention to raise children in the context of a family. And when there are incidents, when there are bad things that are going on, there are all these people that can come around that can help. But it seems like the systems that we have set up in the United States don't exactly do what they're supposed to do. They're intended to do one thing, but they seem not to work very well. And so we are here today to talk very specifically about one of those significant problems and how that works. But I want to at least start with the idea that it's important that we have an understanding that it is God's purpose that we're here to serve, and that is to save moms, dads, and families. And so if you don't know, you should know that moms, dads, you all have a constitutional right to care, custody, control, supervision of your children. Care, custody, control, and supervision of your children. This is not a right that I made up. It's not a right that just came about yesterday. It's not a right that just came about 25 years ago in the case that most people cite having to do with that, called the Troxel case. It is a right that has been around for more than 100 years. It has always been recognized by the U.S. Supreme Court. Every time they've had a chance to recognize it, they have recognized it. And so unless or until a court hinders or obstructs that right, and even that has due process requirements. In other words, you go through a process before that right is hindered, then and only then can that right be hindered or obstructed. So we have a system today that doesn't respect your parents' rights. It doesn't respect moms, it doesn't respect dads, it doesn't respect the fact that kids are supposed to be raised by their moms and dads. They just don't. They don't care. They will always tell you and rationalize that in some way. I don't really care about their rationalizations. I care about the law. I care about the Constitution. I care about people's rights being respected. And when they take away people's rights without due process, that bugs me too. And so when it bugs somebody, maybe they can get frustrated or something like that. When things bug me, I'm a lawyer, so I'll sue somebody over it. And so we have a number of ways of how we handle those things. And so before we get too deep into this, though, I want you to understand that all the people gathered here together, from my office, so from when you first walked in and saw Leslie, wait, there's Leslie. All right. So when you first walked in and you see somebody handing you a folder, to every single person along the way here, whether it's Leslie, who is at the head of our DHR, and I shouldn't say DHR cases, they are JU cases that involve DHR. We don't want to give them to DHR. They're JU cases in JU court, and they involve DHR, but all those active in DHR matters involving Carney and so forth. And so you see all these people here dedicated to and purposeful about that. Why do I point them out? Because they feel purposed just like I feel purposed to go about this. So what that should mean to you, I hope, is that you understand that God loves you enough to send you to a place so that you can get somebody who cares about your situation and will do something about your situation. And you should feel like God, that should be humbling to you a little bit, because God cares about you enough to send you to the right place. It's humbling to me because God entrusts me with you. He entrusts me with your kids. He entrusts me with what you're doing, what your situation is in. And so the one request I would make of all of you, for anybody that does retain us to help you or anything like that, I would hope that you send us a picture of your family. Why? Because it's an easy reminder for us that these are the kids that we're fighting for. This is the mom that we're fighting for. This is the dad that we're fighting for. Because almost always we're fighting for some mom, some dad, sometimes a grandma that is trying to protect a kid. And so all these people are just as purposeful as we are. And so Debbie on this end handles a lot of 1983s for us. That is kind of shorthand for civil rights action. We sue DHR on behalf of parents because they've been deprived of their constitutional rights. And so she handles that. Mitch is a lawyer, and so he does what I do, which is to say that he does everything. And by that we mean that we do those JU cases, and we also do the civil rights actions. And April is all everything in social media, and far smarter than me in everything tech. Which is not a high bar, but nonetheless, she exceeds that bar easily. And I didn't want to go too far before we get through that. So a couple of things that we should get to, so when we're talking about parents' rights, the most important thing I think that you can know about parents' rights is that you have to push back against the people that are trying to rob you of your rights. The thing that we always have to kind of talk our clients out of is that they think that they're just going to talk to DHR. They think they're just going to be reasonable, that they're going to come around, come on, if I just talk to them, if I just show them this and I show them that, they're going to come around. They're going to give me my kids back. They don't work like that. They don't do that. They're never going to come around. They just don't do it. And so when I say DHR, I know we're broadcasting into multiple states, and we do have DHR cases, 1983 actions, civil rights actions, everywhere from Wisconsin to, Wisconsin, we're in a bunch of states. So Wisconsin, New Mexico, North Carolina, Tennessee, Florida, Alabama. DHR doesn't always go by the name DHR. In Alabama, it's DHR. In some states, it's CPS, Child Protective Services. In some states, it's, FCFS in Florida, I think, and TCFS. And anyway, so whatever name it goes by, it's Child Protective Services. They all function pretty much the same way. Why? Because there's a federal statute that controls this. So why, you might think, am I so suspicious of DHR and entities like DHR, no matter what name they go by? Because there are federal statutes that give an incentive to them to do horrible, awful things. There are perverse incentives in the federal statutes. If you snatch a kid and adopt the kid out the back door to somebody else, to a foster parent or whoever, they get paid $1.25 million by the federal government when they adopt that child. For the person that adopts the child, instead of paying through an adoption agency $60,000 to adopt a child, they pay nothing. They can do it for free as long as they get it from the state. The state, DHR, they get $1.25 million. It's called Title IV money. That's Roman numeral 4, not the number 4, but the ordinary number 4. Title Roman numeral 4. They get Title IV money. Second way they get paid is they get paid if they take the kid and put them in foster care. So why would they prefer to put your child, when they do have a problem or issue, they snatch your kid and then they put the child in foster care as opposed to with your mom or your dad or your uncle or your friend or somewhere else, somebody that might have a relationship with you. So why do that? Well, because they get paid if they put the kid in foster care as well. They get paid. And if you have a medically fragile child, a medically fragile child gets them more money than a regular kid in foster care. So a medically fragile child might get them $114 a day as opposed to a regular kid that only gets $39 a day. So the amounts in question are quite different if you put them in foster care as opposed to put them with grandma. So that's why they don't want to put them with grandma. That's why they ignore your request. Hey, if you're going to put them somewhere for a couple of months, why wouldn't you put them with grandma? Why wouldn't you put them with your uncle? Why wouldn't you put them with your brother or your sister or your friend or somebody like that? So they ignore all your pleas. Why? That's why. It's about money. Like a lot of things in life, it's about money. And how do they get the $1.25 million? It's pretty simple. Just do that. So if you think, well, gee, why would they go to all that trouble for the $1.25 million? What's the proof or evidence of that? It's easy. You can actually go to the website for DHR and you can look up something. So if I were to ask each and every one of you, if you were guessing how many kids are male and how many kids are female that are snatched out of homes, and your guess would probably be, what, 50-50, right? So it's not 50-50. And so what is the kid that everybody wants to adopt? It's a girl. Girls are what they want to adopt. Girls are what most parents want to adopt. And so if you look at the numbers with DHR, the numbers should be 50-50 if they were just taking kids for no particular purpose, only because there was some sort of abuse, neglect, drugs, alcohol, or crazy. Those are the 5 reasons why kids get snatched. Those 5 reasons: abuse, neglect, drugs, alcohol, and crazy. So you got to have one of those 5 to snatch a kid. So once you have one of those 5 things and you can snatch the kid, math would tell you, statistics would tell you it ought to be 50-50, but it's 70-30. 70% girls, that's the girls they want to snatch, and they want to snatch young girls, younger than 5 years old. If you got a kid less than 5 years old, they absolutely want to snatch your kid. But even at older ages, they still prefer them, always preferring the girls, 70%. 70% of the time. A lot of times, by the way, they're snatching the boy only because they want the girl, but the boy comes along with because he's in the household. So they got to snatch them both. 70%. That statistic is absolutely impossible if they were doing it in an ethical way. If they were actually doing it in an ethical way, that number would be 50-50 or close to it, darn close to it. But that's not the way it works. So it is sad but true. All right, so the 5 ways I mentioned to snatch a kid, remember those: abuse, neglect, drugs, alcohol, and crazy. So if it's abuse or neglect, then you can evaluate that and you can kind of say it's yay or nay. And so the same with drugs or alcohol. You can do testing on the drugs or alcohol, but the crazy is why we're here today. Because the solution, when you fix the drugs or the alcohol problem, because you can fix that. Because the system is actually designed to fix that. I mean, that's why they are supposed to enter into the situation and maybe remove the kids for a period of time, but then give somebody a chance to fix the drug problem, fix the alcohol problem. If there's somebody who's violent in the home, to excise them from the home, and get them out. So then the violent problem is gone, so the abuse or neglect problem is gone, and then the drugs or alcohol, you can stop doing that. You can do P-test. So I've got plenty of clients that have P cleaned for an extended period of time, but why do they not get it back? Well, because it is the last one. And so the thing about crazy is that you can manufacture crazy. And that is exactly why we're here today, because a lot of you have been victims of the manufacturing of the crazy. And so Dr. Carney is why a lot of you are here today, and he has been the primary moving force in manufacturing the crazy across Alabama, and he has manufactured crazy across Alabama with fraudulent reports, misrepresentations in his reports over the past couple of years, all across the state of Alabama. In 2023, I think he made, $230,000, something like that. And that's just what was reported. We also know that he got paid by a lot of different local entities from DHR in cash, so he got money on top of that. We also know that he was doing SSI psychological evaluations. We also know he was doing VA psychological evaluations. This man has been rampant in his opinion foisting upon other people. Here's what we know about Dr. Carney, and so I will be very specific about the problems that Dr. Carney has created. And he created these by the false and fraudulent reports that he does, which sounds like a serious allegation until you listen to exactly what he's done, and then it should be open and obvious to you. So first thing he does is he lies about the interview. Every single client that I've ever had that had an interview with Jack Carney, they don't have an interview. They don't have an interview at all. So the requirement, the protocol for a clinical psychologist, by the way, he's not a clinical psychologist, he's not. He claims to have a PhD, and he does. He just doesn't have one in clinical psychology. So he's not a clinical psychologist. He has no certifications in family planning, family unit, or anything like that. And so what does he do? He is required by psychological protocols to have at least a minimum 1 hour interview with somebody, and he does not do the interview. Every client that I've ever had, every person that I've ever talked to, had a few minutes of a conversation with him, but they did not have a 1 hour interview at all with him in the least. He does not do that. That is a minimum for the protocol for what you do when you're going to do a psychological evaluation of another human being. You have to do a 1 hour interview at a minimum. What he does do is he sometimes submits questions. And so some of you may have just had a few questions put on a piece of paper and put in front of you and said, okay, fill that out. That's not an interview. That's not enough. It's not enough to have a chit chat with you for 5 minutes after all your testing is done. He does that too. That's not the same as an interview. It's not the same. So he does these things, and he does even worse things. He administers tests that are, well, the best that I can say is he doesn't administer them correctly. Now that can either be out of incompetence or it could be because he is fraudulent in his intentions. I would suggest to you that he's smart enough to know and doesn't care. So he'll administer a number of different tests. He administers one test that predicts future drug use and so forth, which is highly speculative, no science backing it. It's called the ITAT test. It's a test from the 1930s. There's never been a single test anywhere that ever said that it was an accurate predictive behavior test. And he administers that test, and over and over and over again, he testifies about this predictive behavior, which the Alabama Court of Appeals has said is speculative and can't be entered into evidence anymore. But somehow, some way, JU judges across the state of Alabama still accept it. They should never accept it. It's garbage, but they do it, and they use it as a justification to take kids. Second test that he gives, these are not the only tests that he gives. I'm just going to give you a couple of examples. Is the MIMC test, which is the Milan Clinical Multi-axial Inventory Test, otherwise known as the Milan test. And it's not spelled like Milan, the city, it's spelled like Milan, the individual, which is Millon. And so in the Milan test, you have to have a pre-existing personality disorder before you administer the test. He gives it anyway. I have at least 100 clients that have no pre-existing personality disorder of any kind, and he still gave them the Milan test. So what does that mean? If you give somebody who has no pre-existing personality disorder of any kind, if you give them the Milan test, you over-pathologize the individual. You over-pathologize whatever is wrong with them. And so it is absolutely wrong. By the way, you can, for $89.95, you can go buy it yourself if you want one. You can go buy the actual manual for the test. Anybody can. You can go online, anybody can buy it, $89.95. And if you buy the manual for the test, it says in the manual, you cannot administer this test unless there is a pre-existing personality disorder diagnosis. I got at least 100 clients that have never, ever, that have been administered that test, but have never had a pre-existing diagnosis of a personality disorder. So the guy is doing what DHR wants him to do. So when DHR calls on him, they want him to issue a test. They want him to give a result that is a negative, horrible, horrific result. He is doing something that is by design false, fraudulent. You know, it is clear that this is no accident. It is clear that he wants to do what he's doing, and he does it intentionally and purposefully. And so that is what we can do something about. And so that's why we're having the town hall, because I know that there are thousands of people literally all over the state of Alabama, and this guy has done testing all over the state of Alabama. I have cases in St. Clair County, Shelby County, up in Blount County, I don't know, we can name a county. Mitch, you just went to where? Morgan County, and so all over Alabama, and no matter where you go, I thought St. Clair County, certainly his reach doesn't reach that far, but you know what? Oh yeah. They sent them from there to Mobile, Alabama, so that they could go to their office and get that test. Why? Because they wanted to make that person appear crazy. So the person having no sign of anything having to do with an issue at all is all of a sudden diagnosed with a boatload of things and then given 2 pages of ridiculous requirements. It is deceitful, it is evil, and more than anything else, it robs somebody of their family. It robs somebody of their family either for, maybe just 6 months or a year, but maybe forever. And this is the basis for robbing people of family. It is an evil thing. So for each and every one of you, you might fall into any number of categories. And so I'm going to you'll see some signs that kind of divide people up into groups. And so we have an evaluation that we take everybody through. If you go through the packet, you'll see that one of the things in that packet is an agreement for us to evaluate, to do an evaluation of your circumstance. So I don't know what group you fall into right now. That takes a little bit of due diligence. That means we might have to get some medical records. That means we might have to request a report maybe from the esteemed Mr. Carney or from the other people. It means we may have to do some other things too. So, but bottom line is, to do that evaluation costs some money. That's $1,500. And so, but that's for people that do not have an ongoing case. If you have an ongoing case, we'd be happy to help you. And so the different categories that I would kind of divide people up into, and some people may fall into multiple categories. And so the first category I would refer to is just having an ongoing JU matter with a Carney psych eval. And so if you have an ongoing matter with a Carney psych eval, what I just said about the evaluation really doesn't apply to you, because we can represent you right now in a case, and then where you are in the case matters, and then there's a fee attached to that. And then the second group that I would refer to would be a JU matter that is recently resolved with a Carney psych eval. And by recently resolved, you got to keep in mind there are deadlines to these things. And so you have 10 days. Only in Alabama you have 10 days, which is ridiculous. It just tells you that they don't really want you to appeal. You got 10 days, and that's it, to appeal a JU matter in the state of Alabama. Now, you can do some things that can extend that date, like filing a motion for new trial or motion for JNOV. And the other thing is that if it's recently resolved, but beyond that 10 days, you can still file some motions, what's referred to as a Rule 60 motion. So you have 120 days to file that. If it's 1 through 4, I don't want to get too esoteric. If it's the first part of the rule, which is 1 through 4, and 5 and 6 go longer than the 120 days. So that's a Rule 60 motion. So in other words, there's things that we can do if you've recently resolved one of these cases. So the third group would be a JU matter that is long resolved with a Carney psych eval. Because what we'd like to do is to start attacking these old cases that, even though it might be done, even though you might have even lost your parental rights, we still want to find a way to go back and attack those. And part of that has to do with a lot of the other parts of this groups that I'm going to go through here. Once we filed a lot of these lawsuits, I think we can use the leverage of that to go back to some of these old cases and start making judges aware of just how awful Jack Carney is, especially when in most of these cases, a lot of the problems that I've pointed out with Carney's reports have never been litigated in front of that court ever. In other words, everything that I'm saying about those reports, they've never been brought up. The issues that I'm talking about, they've never been argued to a judge. They've never been argued to that judge. These things need to be brought up. They need to be litigated, and to rob somebody of their kids, to take away, and I don't care if there is an adoption of the kid. Undo the adoption. If the adoption's been done, it was a wrongful adoption. It never should have been done. And they will whine about that. I know you're gonna, I don't know, can we really undo an adoption? Well, it never should have been done in the first place. You stole my client's kids, so cry me a river. So I don't feel sorry for those things. I really don't. I don't care. If it never should have been done, it never should have been done. And so the fourth group is a group of double billing. And so this is what Jack Carney does. He gets paid as an expert in order to testify for DHR, and he gets paid a fee for that. The problem he has is that in his agreement, which we have at least one of, but we have others, because he tries very hard, you all might have known, to not give you your reports and to not give you your information. So we do have some of them. And so in the agreement, he refers to himself as a treating physician. The problem with that is that he's not. He's an expert. And so you can't be both a treating physician and an expert. That is a lie. What's a lie? Well, a lie in legal terms is fraud. So it's fraudulent, but he also double bills. This is what he does. So he'll have you go to do a psych eval, for instance, and when he sends you to the psych eval, he will then have somebody, he will get paid by DHR to do the psychological evaluation, and then he will bill your Blue Cross Blue Shield or your United Healthcare or your Medicaid or your whatever your healthcare coverage is. So he will double bill that. So he hasn't done that with everybody. So, I mean, my guesstimate would be something like at least a third of my clients that have Carney or involved with Carney, at least a third of them have been double billed. That's fraud. That is criminal behavior, but that's not my job to do anything about criminal behavior, but I know what to do about the civil stuff, and that is to sue him for fraud. It is fraud. And so that he is subject to litigation for, because he is double billing people. You can't be both. The representation that you have to make to a health insurance company when you bill them is that you're either a treating physician or it is necessarily related to some particular cause that you are treating them for. Still treating. So his contract is contrary to what he's doing, which is a fraud. And also, in addition to that, how he bills the insurance company and the representation he necessarily makes to the insurance company, also fraud. So he's a fraudster. It is slimy and wrong, but that's what he's doing. So the double billing issue is significant, and it is a problem for him. That problem only gets worse when he does this in the context of SSI claims. Social Security income and applying for Social Security is something that he also gets involved in. So some of you may be here for that, some of you may not, but I know we're probably going to have another town hall maybe in the city of Mobile, because I know we have at least 300 people in the city of Mobile that have been defrauded by him in an SSI context, meaning that he did an evaluation for SSI and he billed the federal government for doing an interview, for instance. But as we know, he never does interviews. I have literally never met a human being that ever went to Jack Carney that ever had an interview. Never. And so he did the same thing in the SSI context that he's done here. And so he does the same thing with the VA as well. So why does all that matter? Well, in an SSI context and in a VA context, we are suing him under what's called the Lincoln Law. The Lincoln Law means that you sue somebody because they are defrauding the federal government out of money. And then the next step, of course, is to undo all those fraudulently obtained denials of Social Security. Think about that. Somebody is applying for Social Security. They have no way to make a living. They're disabled in some way. And what does he do? He shafts them out of the ability to have any income whatsoever, leaving them pretty much stranded. If you don't have a way to make a living, but this guy shafts you out of the SSI, then what horrible circumstances he sticks people in. So he doesn't care. He's just making money off of you. And he has a willingness to do all this stuff. So, so we have, let's see, we have at least 6 different groups. And so the last one are civil rights actions. And so those are people that we are evaluating to see if there's a civil rights action. And by that I mean where I kind of started in the beginning, and that was with the idea that you have a constitutional right to care, custody, control, and supervision of a child. That's your child. It's not theirs. And DHR treats them like furniture, and they think they can shove them around to wherever they want to put them wherever they want, and move them from one place to another. That is not their right, although they believe it is, and they certainly act like it is, and they certainly don't respect your rights. And so we repeatedly sue them as often as we can. We have at least a half dozen that we're in the process of filing suit on now. One of those has to do with molestation. One of them has to do with just snatching a kid they never should have snatched, and gave it to an ex-husband, by the way, who was living with a molester, or at least allowed a molester to have access to the kids. So DHR does this ridiculous and stupid, awful stuff all the time. If they have no cause to snatch your kid, then that is a civil rights violation. Every time they file a petition and they lie in that petition, that is a civil rights violation. It is what's called a procedural due process violation, and your right is what's called a substantive due process violation. So we get through all this stuff. I know I'm throwing a lot at you, and so I appreciate your attention to help with all this. And so there's one other thing that I'll mention before we move on, and that is just to give you a little bit of clarity. So when I say that, we have an evaluation that we do, and that's one of the things in the package, and that's the $1,500 that I mentioned before, and that evaluation is done for everything except the ongoing JU case that's ongoing right now. And so the reason we evaluate it is to evaluate which one of these groups that you fit into, and some of you, like I said, are going to fit into more than one group, and then we'll apply the $1,500 to that case if there is one for you. And so for most of you, you're going to fit into one of those groups, otherwise you probably would not be here. So we're going to do Q&A in a minute, but there's one more thing that I would mention, and that is that we have a support group that we have for women that are going through this circumstance. And so we want to do one for men too. We may do one for men maybe in the future, but we're going to start with the ladies because women tend to show up at these things better than men do. Sorry guys, but you don't tend to show up. And so why do we do this? Well, we do this because you got a lot of people that are in a lot of pain, and they're having difficulties, and they're having shortcomings, and leaning on one another, because if all of you are similarly situated, then maybe you can lean on each other a little bit, and you can meet, and you can talk, and you can be supportive of one another. There's a verse in James that says, as we confess our wrongs one to another, that there's healing in that. There is healing in a support group setting. There's in fact, a therapist I was just talking to the other day was telling me that there's a lot of evidence out there for really good help happening in a support group setting, that there's healing in that it's successful in helping people. And so don't be afraid to reach out. If you're in a predictably painful circumstance, having your children taken from you is awful, and it means something to go through what you're going through. And so so we have a support group. The young lady that I'm standing in front of raise her hand. She is the lady who is organizing the support group, and we have handouts for that. So please grab one of those before you leave. Doesn't cost you anything. Just join up. The point of the support group is support. It's to help people that are in this particular situation. And so we'll do Q&A, and so we're happy to start that whenever somebody wants to. And so
Raise their hand.
And so we have the phone that if you look in the packet there. And so I know some people are online, so I don't know if the number's been given out online or not. But if you don't have any questions for me, that's fine, because I'd like you to hear from Mitch. Mitch is also an attorney in our office, and Mitch Mitch has some stuff too. So, yes, ma'am.
I have a question. Can you tell me a little bit about parents' rights when it comes to safety plans?
Okay, safety plans. So safety plans are DHR's way of super manipulation. It is an evil way of going about things, but it is what they always do with regard to safety plans is they will always threaten you with something like, you don't enter into the safety plan, I'm going to take your kids away from you. You're never going to see your kids again. Actually, I just drafted a complaint suing somebody for a civil rights violation based on a safety plan, and that's what they told my client, was you're never going to see your kids again unless you sign this safety plan. Of course, she's in tears, she's freaked out, kind of justifiably, because she believed this, because there's no advice for that like I'm not there, so I can't tell her, don't believe that awful woman, And so the thing about safety plans is, look, if they don't have an order from a court, then don't let them in your house, for one thing. But I'll get to I'm going to answer. So first of all, don't let them in your house. But once they are in your house and once they have been there, the thing about safety plans is that it is an agreement and you can cancel it. And so what I generally do when I get involved and somebody's already entered into a safety plan is I will cancel it. And here's why. Because it's an agreement and you can cancel it, and what they'll always say is, well, if you cancel it, then we're going to take your kids. In other words, they'll make the same threat that they make at the time that they enter into it. But they'll extend the safety plan, then they'll extend the safety plan, then they'll extend the safety plan, and then they can invoke the court's jurisdiction and snatch your kid anyway and take you through the process. So in other words, if you're going to have this fight, you might as well start the fight. You know? Yeah.
Okay, so I did agree to the safety plan. About a month ago, the safety plan, I signed for the safety plan to be closed, and the kids are in my home, but DHR is still coming for home visits and drug tests. Why?
Yeah, well, I would tell them to go away unless they have a court order. Yes, you can tell them to go away. Their threat for that may be, well, you know, we're going to snatch your kids. If you had the ability to snatch my kids, then they wouldn't be in my house, for one thing. So whatever threat they make, I think you have to just understand that there are only two choices. So think it through logically. And so there are only two choices. It's either a bluff or it's real. And so if it's real, and you already have the kids in your home, I would suggest it's a bluff. Whatever they're going to say, it's going to be a bluff. But they have no right, and if the safety plan has been cut off, and I would never tell anybody to enter into a safety plan. They will change the safety plan, they'll lie about the safety plan, they'll manipulate the safety plan, and they'll manipulate you with it by saying, well, I'm going to snatch your kids if you don't do this. Well, if they had a reason to snatch your kids, then why wouldn't they snatch them anyway? And if the safety plan is to take your kids and hand them to somebody else, then you end up with no control. So this is why it's horrible to have a safety plan, because you're talking to DHR and you're at their pleasure when it comes to a safety plan. At least if they invoke the court's jurisdiction, then at least you have a judge telling DHR what to do instead of DHR telling you what to do. And so it puts you, if you enter into a safety plan, you're in a position of weakness. At least if you force them to invoke the court's jurisdiction, at least you can get the court, to order them to do things, because they have to obey the court. They think they're in charge. They really do. DHR always thinks they're in charge, but they're not. There's a judge. The judge is in charge. The judge orders them what to do, and the judge has to obey the law. And the judge doesn't obey the law, then you can take him up on writ of mandamus, or you can take him up on appeal. So it's judges want to be right too, and they don't like getting reversed. And so the nature of kind of how juvenile courts are organized is the way they work is, let's put it this way, not productive and perhaps not the best thing. Why? Because everybody's getting a paycheck from the state except for me. I work for the mom or the dad, and I'm the only one in the courtroom not getting paid by the state. So everybody else is getting paid by the state. GAL's getting paid by the state. The judge is getting paid by the state. DHR lawyers getting paid by the state. The therapist is getting paid by the state because DHR sends them to the therapist. DHR has people that they pick out that they like, that they send the people to. They'll send somebody to their therapist that they like, their psych eval. That's why they send them to Carney. By the way, I've had counselors, psychologists that have told me that that they won't send in, that DHR won't send anybody to them because they'll give an honest psych eval. They don't want an honest psych eval. They don't want a psychological evaluation that's real. They want one that shafts the person they send to them. And so, so we have, so safety plans are a point of contention over and over and over again. I would tell anybody, don't enter into a safety plan at all. You're better off having if they do follow through with the threat and actually invoke the court's jurisdiction, better, lawyer up, go to court. Fight them in the 72-hour hearing, which is the very first hearing, and they have to prove something. And even then, dependency hasn't been proven until they get to an adjudicatory hearing, and that's down the road some. But you have time to get some evidence together and stuff like that. You got to fight them tooth and nail on everything. The failure most of the time in juvenile courts is that the lawyer representing the individual who's at issue, they agree to things, and I don't understand why Well, I understand why they do it. I don't like that they do it. So they agree to it because it's the easiest thing to do. But usually in a 72-hour hearing, the way they usually work is that you go into a 72-hour hearing and everybody walks in and the DHR lawyer says to the judge, well, Judge, this is the evidence we're going to have. We're going to have some evidence that, that there's some drug use, there's some of this, there's some of that. And they're going to just say that to the judge. The judge is going to, okay, well, that sounds like I ought to grant it then. So I guess I'll grant it. And Judge, we disagree with all that. We don't think that's right. And that's about all they say. But there is no actual hearing. The judge just says, okay, that's what I'm going to do. And then he grants it. And that's what happens most of the time. What you have to do as a lawyer is instead of saying that, you say, Judge, you got to have a hearing. You got to call witnesses. You got to have proof. You got to have evidence. I get to cross-examine them then. So you got to prove it. You got to show it. You don't just agree to it. You don't just go along with it. You got to force them to have an actual hearing. But most lawyers don't, which is sad and not my preferred manner of working, which I know makes me obstinate. It means that I appear to be difficult to them. But that's okay. I don't care. So it's not my job to please them. It's my job to represent a client. It's my job to defend a constitutional right. And that, to me, is far more important than pleasing what is almost always a false narrative of some sort. So, Mitch, you want to come on out, and so you'll now get to meet Mitch, and so he's going to talk to you about a few things. If you've got any questions, you can always text them in, and so if you text them in, we'll be happy to answer those questions and so forth. We have one more here. Yes, ma'am.
As far as our soft diagnosis, that's a Smith side, right? That you take it on paper results. Because in my situation, I can deal with people or the abuse of people which then are taking that fuels in the fire.
Sure. For the false diagnosis, the one thing that, I hate to say it, but lawyers don't always do a good job of this. And so there's a rule called the Dauber rule, sometimes called the Daubert rule, depends on how you want to pronounce it, D-A-U-B-E-R-T. And so that rule's handed out by the Supreme Court years ago. And so that is the rule that's been adopted by every state. And so every state has this rule, and so including Alabama, by the way. And so there has to be proof and evidence having to do with the validity, the scientific validity of what you're proving. And so in the state of Alabama, and in particular in regard to Carney's reports, he does a lot of reports where he has this predictive behavior. Well, there are two prongs to the rule. The first part is relevance, and so that excludes his reports that are predictive right off the bat, because a lot of them are predictive, and so a lot of his pronouncements are predictive in nature. He's predicting behavior. I don't think this woman will protect her kid in this circumstance or that. That's predictive. He's predicting the future. So in Alabama, the Court of Appeals has said that that's speculation, and what you do, instead of relying on the speculation of some idiot expert who's in quotes, you rely on actual evidence. And so the case that they said no to that in is that, well, we have actual behavior from this person that is the opposite of what was predicted. So let's believe the behavior as opposed to the idiot prediction from the idiot expert. And so the first prong of that, it fails. The second prong has to do with that scientific validity. And so the scientific validity of the test. So in other words, you got a lot of lawyers that aren't challenging the tests, and you got to exclude it because of that. The other thing that a lot of folks don't do is you don't go get discovery and they don't go get the reports. You got to go get the reports. And so you got a right under the HIPAA statute to go get it. And so one of the things we'll be doing in all these cases that all those groups that I just laid out, is that for the people that we don't have reports for, we're just going to file suit under HIPAA. We're going to give them 10 days to give us a report, and we'll have our client sign a HIPAA release. And if he doesn't give us the report within 10 days, we're going to file suit against him. Why do we do that so liberally? Because under the HIPAA statute, he's got to pay us attorney's fees. So we'll sue him, we'll get it, we'll get the reports, we'll get the stuff, we'll get all the information, and then he's going to have to pay me, which I appreciate, him paying me. I like that, so I'm okay with that. But as far as the report you're talking about, you got to attack the report, and you can't let it go. And of course, your enemies are always in in that courtroom environment are always going to feed on that, like 1,000 little, scavenger fish, on the corpse of of a whale or something. So yeah, they're going to feed on that, but you can't. You got to defeat it. And if you know as much as you got to know more. And when I say you, I mean not you. I mean your lawyer has to know what the tests are, and you got to know what the problems are with the test. And by the way, if he doesn't know about that, there's an easy fix for that. You can consult with therapists, you can consult with counselors, and they'll be happy to tell you, like, hey, what's an ITAT test? And any psychologist, any clinical psychologist with an IQ above moron will tell you that it's a garbage test from the 1930s. It doesn't mean anything. So you can't, and not only that, the other thing he does, which I didn't mention before, but I'll mention now, is the other thing he does is he always tries to avoid telling you what the margin of error is on these tests. I have never seen him once have a test where the predictive value of what he was saying about a particular person was above 50%. Above 50%. In other words, every single psyche eval that I've ever seen, the predictive value was less than that. In other words, like a 75% chance that it was wrong. So he makes these predictive assumptions, but it's wrong if you do the math. But you got to know how to do the math. And so he'll tell you you can look up what the number is on the test in particular. And like on most of the tests that he does, all the predictive values are, you got between 0 and a 1.0. And so if you got like a 0.5, so most of them are 0.4, 0.5, or 0.6 for all the tests that he's ever seen. And so if you take that number, you take like if it's a 0.5, multiply by 2, it's 25. That means 25% chance of being right, 75% chance of being wrong. And so, I don't know, if you just know how to do a little bit of math as a lawyer, and some lawyers are math challenged, but I promise we can get this done. Buy them a calculator. And so, but you gotta know how this works enough so that you know to do that, because you can blow this stuff out of the water, but you gotta know. You gotta know something about it. Does that make sense? Yeah? All right. So, yeah, sure.
First of all, thank you for what you've done.
I appreciate that.
I don't know that my case fits in cleanly into any of the categories you spoke about, but I'm curious if it falls into this potential civil tort that you're gathering information for. Is that going to be kind of everything outside of some of these categories you talked about?
Yeah.
Or?
So I think most of the lawsuits against Jack Carney are going to be, I'm sorry, I forgot the microphone.
Question for the
Yeah, so I'll repeat the question. So he was asking about the torts that are going to be brought against Jack Carney, and so I was just going to say that most of the torts that are going to be brought against Jack Carney are going to be kind of characterized, I would characterize this way, is the first count is going to be basically a psychologist malpractice kind of claim. It's a negligence claim, and that is that he owes a duty of care to the individual that he is treating, and so the second count is going to be a fraud count, and the fraud is going to come in multiple forms. For some people it's going to be the billing, for some people it's going to be the billing and the representations that he makes about being a treating physician or not being a treating physician, because he's really an expert, not a treating physician. And so the reason why I'm going to frame it that way is because he is going to be forced, and his lawyer is going to be forced, to make a choice. You got to either say that you're a treating physician or not. Ordinarily, the defense to the first one, the psychological malpractice, or the psychologist malpractice, would be, hey, I'm an expert. I'm not a treating physician. The problem he has is that his written documents say different than that. Yeah, and the second problem he has with that is that he has billed a lot of people's insurance, which also means that he is claiming to be a treating physician. So, but his own even when he didn't bill somebody's insurance, though, he still has his own written documents that say, that I'm treating you. And he actually makes people make all kinds of promises about malpractice insurance and how you're not going to sue me for this and that, and you're not going to sue me for all this because I'm your treating physician, I'm a swell fellow and a nice guy, and he has all these representations in his documents, that are ridiculous and over the top. But all of that includes a reference to himself as treating physician, which means it's a representation, and it's a lie, because he's not.
My case does not involve Carney, but it involves DHR.
Okay.
So I don't know where that might fall.
Well, that last category is 1983 actions against DHR, and so we have a lot of 1983 actions that we bring against DHR that have nothing to do with Carney, and so Just filed one the other day. So you know, the problem with DHR is that, you know, care, custody, control, and supervision of a kid, that's the constitutional right that they're violating. And so as long as they're violating that constitutional right, and especially when they lie about it, because lying to get jurisdiction or lying to get the court to invoke their jurisdiction, any lie told to a court, whether it's in a petition or a 72-hour hearing or even testimony. I have one case where there was an affidavit filed by a caseworker, and in that there are 8 paragraphs in the caseworker's affidavit, and there are at least 7 lies told through the middle 4 paragraphs. And so every one of those lies is a civil rights violation, especially when it leads to some sort of deprivation. That's a substantive due process violation. In other words, being deprived of your kids. That's you know, I mean, constitutionally, it's a liberty interest. That's a substantive due process violation. So that's, I mean, without getting too esoteric. So the procedural stuff, which is the lie, leads to the substantive stuff, which is the deprivation. So one leads to the other. They work together to deprive you of your rights. Yeah. So, and it's but yeah, there are lots of ways to bring cause of action against DHR. Most importantly, though, you know, we have to, there are qualified immunities that apply and stuff like that. So we're very careful about how we draft contracts, but we're very careful about how we draft contracts. We're very careful about how we draft the complaint because of those immunities and so forth, but we've been doing it for a while and we're pretty good at drafting around those things. Basically, we sue them individually, and that's the biggest way that you get around most of that. And then there are a few other things that we have to do as well. So, yeah.
DHR?
Absolutely. We sue individuals. So we sue individual caseworkers within DHR, and then sometimes we sue DHR as well as a whole, but we don't do that every time. Depends on the evidence, depends on the case, depends on the matter. We have to evaluate it. Yes, ma'am.
Sure, my question about HIPAA violation. What I see with Dr. Carney was did sign the waivers for him for the court to go pursue before off. It still said he would anyway. That had to be laid into it and show the court. Please,
Yeah, so the question she asked.
You go to see Dr. Carney, he didn't sign any of the document agreement.
Yeah, so the question she's asking is, what if you went to see Dr. Carney, but you didn't sign any of the waivers, but you did do the tests, but then he went ahead and sent the test to DHR anyway. That creates a problem for him because it's a HIPAA violation. So that is one extra thing that he would get sued for in that case that he would ordinarily not get sued for, because that's a HIPAA violation. So he violated HIPAA by disclosing it when he didn't have the right to disclose it. So even if he's an expert, he still can't disclose it without you waiving your rights, especially when he claims that, you know, he's treating you. That's what he claims. So in his documents, he may claim differently, or his lawyer may claim differently in the future, but he's kind of stuck with that. And so you know, one of the things that I would you know, I mean, I know the reality is that you know, people that represent Carney are listening and listening to me now. And I know that and I understand that, but part of the reason why I'm willing to say the things I'm willing to say and do the things I'm willing to do is because most of everything that he's done is already done. In other words, there are documents that show it or not. In other words, you know, my client, you either signed a waiver or you didn't. I mean, if he got a signed waiver from you, then great, show it. But I mean, if he has one, then he can show it. Otherwise, you know, he's not. So that's what I mean, is that most everything is already done. You know, if the report is created, the report is created. If the psych eval is created, the psych eval is created. And he can't now undo that at this date. So you can't undo history, you can't undo the documents. So he's stuck where he is. So praise God. I asked Mitch to come over here, and then I started talking for another 20 minutes. So, well, we thank you for your time and attention today. Appreciate you guys coming out. For those that came out, we have, I know a lot of people that are here with us streaming and other means. And so if you got any questions or problems, you can always give the office a call. You can always get in touch with us, whether it's me or Mitch. And for that matter, any of the other crew here, and anybody that wants to visit the tables over here and go through that process, we'll be happy to help you. So take care. All right. And God bless. Hallelujah. Thank you much.